We now move on to the polluter pays principle. The origins of the polluter pays principle can be traced to economic theory, which states that the producer should bear the cost of externalities such as environmental pollution resulting from the production or consumption of the good or service produced by him or her. In terms of polluter pays principle as a legal principle, it is useful to look at some of the early recommendations of the Organization of Economic Cooperation and Development, which promoted the partial cost internalization approach towards the polluter pays principle. It basically constitutes of two concepts. One is the cost allocation principle and the other is the non subsidization principle. The cost allocation principle is based on improving efficiency and encouraging rational use of scarce natural resources. Here, the government is responsible for deciding pollution prevention and control measures to ensure that the environment is in an acceptable state, and the polluter is required to internalize or bear the full cost of carrying out these measures. These costs should then be reflected in the cost of the goods or services which cause the pollution. In this case, nothing has to be paid to anyone. Therefore, when we state that the polluter pays principle is being applied, no actual payment is being made. The other important element of this partial cost internalization approach of the OECD is the non subsidization principle. The idea is to avoid distortions in international trade and investment arising from adoption of differential pollution abatement mechanisms or methods by the polluters. It's based on saying no to government subsidies. However, exceptions or special arrangements have been made possible. In other words, the polluter pays principle does not apply in absolute. Exceptions have been envisaged to it. The other element of the OECD approach follows a wider scope of the polluter pays principle. This is known as the full cost internalization approach, which includes the costs of accidental pollution caused by hazardous installations as well as control, cleanup and rehabilitation costs. This is reflected in the 1989 recommendation of the OECD. Subsequently, the 1991 recommendation of the OECD also talks about internalization of damage costs. At the international level, the important source of the polluter pays principle is the Rio Declaration of 1992. Principle 16 of the Rio Declaration states that national authorities should endeavor to promote the internalization of environmental costs and the use of economic instruments, taking into account that the polluter should, in principle, bear the cost of pollution with due regard to the public interest and without distorting international trade and investment. If you look at this statement, the responsibility is cast upon national authorities. Therefore, this discussion is taking place at the international level. The national authorities should endeavor to promote. Therefore, the obligation is not absolute or obligatory in nature. The Rio Declaration formulation goes beyond the OECD definition because it's not just speaking about internalization of environmental costs, but also the use of economic instruments. It then asks national authorities to take into account the use of very non-binding language, also talks about bearing the cost of pollution, which seems to suggest the full cost internalization approach, suggesting a wider meaning of the term cost in this case. The Principle 16 formulation of the Rio Declaration has been applied at the international level and the regional level widely. However, the content and legal status of the polluter pays principle remains unclear. It's not an absolute principle, as I stated before, because a number of exceptions are permissible. In marine agreements, both at the international level and at the regional level, parties are required to apply the polluter pays principle, and this language is included in the binding operative provisions of these agreements. In other cases, however, it is used in the form of guidance, therefore suggesting a softer language of the polluter pays principle. The language of the polluter pays principle is also included in environmental liability agreements. In some cases, it is referred to a general principle as well. For example, in the preamble to some conventions, as well as in the International Court of Justice decision in the North Sea Continental Shelf case of 1969. Insofar as domestic environmental law is concerned, we find explicit as well as implicit references to the polluter pays principle. We are going to discuss two decisions of the Supreme Court of India, but subsequently the polluter pays principle has been explicitly mentioned in a number of other Supreme Court decisions, decisions of high courts, as well as decisions of the National Green Tribunal. Another element of the polluter pays principle is its specific inclusion in legislation such as the National Green Tribunal Act, which requires the National Green Tribunal to consider the polluter pays principle as well as the precautionary principle and sustainable development while issuing its orders, etc. We will first talk about the Bichri case. In this case, the Supreme Court said that the polluter pays principle has now come to be accepted universally as a sound principle and has gained almost universal recognition. This observation of the Supreme Court was based on a journal article discussing the polluter pays principle in the context of the OECD and the European Community. In other words, the Supreme Court is looking at the polluter pays principle as a general principle of law prevalent in other systems. There is no reference to international environmental law such as the Rio Declaration, and there is no reference to the provisions of either the Constitution of India or domestic environmental legislation in order to explain the inclusion of the polluter pays principle. The Supreme Court then went on to observe that in light of the application of the polluter pays principle, the offending industry is responsible for repairing the damage caused by it. This decision of the Supreme Court has been subsequently referred to in a large number of decisions. The other important decision of the Supreme Court where the polluter pays principle was expressly mentioned for the first time is the Valor case. In this case, instead of relying on the OECD and the European Community, as was done in the Bichri case, the Supreme Court relied on two sources of the polluter pays principle. Number one, implicit inclusion of the polluter pays principle in the constitutional provisions relating to environmental protection as well as in environmental legislation such as the Water Prevention and Control of Pollution Act 1974 and the Environment Protection Act 1986. The Supreme Court also relied on the status of the polluter pays principle as customary international law. There was no reference to the Rio Declaration in the Valor case either. It is pertinent to mention that in this case, the Supreme Court, although it states that the polluter pays principle is a principle of customary international law, this is not the general practice. The polluter pays principle has not yet been established as customary international law. As I mentioned previously, the polluter pays principle has been included in domestic legislation as well. In addition to the National Green Tribunal Act, we also must refer to the Hazardous Waste Management, Handling and Transboundary Movement Rules of 2008 and similar rules for electronic waste which were published in the year 2011, both of which state that certain entities are responsible for preventing environmental damage and they are liable in case of their failure to do so. There are a number of issues which must be discussed in the context of the polluter pays principle. Firstly, who is a polluter? Is it an industry, the government or members of the public? What does the polluter have to pay for? Past, present or future pollution? When is the obligation to pay triggered? When violation of an environmental standard takes place and there is occurrence of actual harm? Where there is violation of an environmental standard without occurrence of actual harm, what is known as the potential to harm. The occurrence of actual harm without violation of an environmental standard could also result in the invocation of the polluter pays principle. The next important question is how to determine payment. Should it be a percentage of annual turnover formula or absolute liability principles, etc. What is to be paid by the polluter is also an important question. Should it be monetary compensation to victims, costs for environmental damage to affected persons, or into a government managed fund, or punitive or exemplary costs. The final question is, who has to actually pay? Since it is the polluter pays principle, the traditionally held view is the polluter has to pay. But in certain cases, the government may have to pay, or in certain other cases, the costs may actually be passed on to members of the public. Finally, before concluding the presentation, we should also discuss the concept of liability. There are two main forms of liability: fault-based liability, where the proof of the polluter's negligence is required, and no-fault liability, where the burden of proof is reversed. There are two main forms of no-fault liability: strict liability and absolute liability. While strict liability is subject to certain exceptions, this is not the case insofar as absolute liability is concerned. Further, in case of strict liability, there is a cap on liability, which means that beyond a point, the polluter cannot be made to pay, whereas in case of absolute liability, the liability amount is uncapped. Both of these concepts have been applied in the context of domestic environmental jurisprudence. In summary, this presentation has familiarized you with three ideas: sustainable development, precautionary principle or approach, and the polluter pays principle. In the context of each of these three concepts, principles, or approaches, as the case may be, we have noticed that there have been considerable developments in the context of international environmental law, which has subsequently also found a place in domestic environmental jurisprudence. However, a number of issues remain outstanding in the context of each of these three concepts, principles, or approaches. Thank you.